Good morning, everyone. My name is Nigel Nordone. I'm the head of tax at Qdos. And in today's webinar, I'm going to be talking about statements of work and answering, or hopefully answering, the question that we get asked a lot at Qdos: do they guarantee an outside IR35 status? So in this session, we'll be talking about what is a statement of work and how it is used, when to use a statement of work and how it impacts IR35 status, and how to compliantly engage contractors. A statement of work has become a key part of IR35 strategy discussions for managing the IR35 reform. It's however been presented as a way to engage contractors in order to avoid the rules and guarantee an outside IR35 status. So today we'll explore what a statement of work actually is, how it's used, how using a statement of work impacts IR35 status, and how to compliantly engage contractors. So what actually is a statement of work? A statement of work forms part of a managed service agreement between two parties, usually the end user and the supplier, such as the consultancy business, for fully contracted out services. It's a document which details the specifics of the piece of outsourced work, i.e. when you're outsourcing a project or service to a supplier, the statement of work will document the deliverables and boundaries of that project. It's also often far more detailed than your standard schedule, which accompanies a contract for services, as it will include exactly what is required within the project, key milestones, payment terms, timeline, as well as specifics around how the project will be completed. Whilst there's no set format for the document, it should include as much information around what is included under the agreement, preventing any later disputes around what was included in the costing and what would be additional. Essentially, when you draft a statement of work, the whole point behind it is that all parties involved in the process, in the chain of delivering the work and receiving the services, should know exactly what they've signed up for, what will be delivered, when it will be delivered, over what time period, and the costs, etc. involved. So there should be no areas of dispute at the end of the period that the services have been delivered as to what was expected and what was actually delivered. So generally, a statement of work will accompany a master service agreement in place that governs the overall relationship of the parties. The master service agreement will include the high-level topics such as confidentiality, indemnification clauses, whilst the statement of work provides the specific project details, usually in the form of a schedule or an addendum. This is similar to a contract for services, which would usually include the overarching terms and conditions and the schedule which accompanies it. The difference, however, is that a contract for services is used for the provision of labour, in other words, bums on seats, if you like, and a statement of work is used for the more project-based work, i.e. the delivery of a specific service. So you're not, when you engage in a genuine master service agreement statement of work, you're looking for the supplier to provide you with a service, not an individual contractor or a group of contractors. So it can be common and legitimate practice for either a client or supplier to engage a contractor via a statement of work to complete a specific project or element of a project with clear outcomes and deliverables. This is different, however, to engaging a contractor for their time and materials, as a contractor must be responsible for the specific outcomes of a project and paid a fixed fee for the project or on a milestone basis. Engaging a contractor for clear deliverables and outcomes as opposed to time and materials is a cost-efficient way of procuring resource. A contractor engaged on a 6-month contract could result in them having little to do during some of that time due to the nature of the projects that they're engaged on, whilst the same contractor engaged to deliver the specific outcomes needed will be paid purely for the delivery of those outcomes. And so the business achieves the same results without wasted expense on time spent before or after the project completion. That's not to say that this is exactly how all firms view a new statement of work. So what is a statement of work? When talking about statements of work, it's important to remember that it may be referring to either the actual statement of work document itself, which forms part of the managed service agreement, as I explained so far, or the use of a statement of work as a method of engaging contractors with the aim of circumventing the IR35 off payroll rules. due to come into effect on the 6th of April 2021. So we're now going to look at the impact of a statement of work on IR35 status. With clients wanting more efficient ways of procuring services, IR35 reform has led to an increase in agencies and specialist firms reconsidering how they engage with contractors that could better support IR35 compliance, and the statement of work has become a core part of this discussion. Some suppliers believe that merely putting in place a statement of work will provide the contractor with an outside IR35 status and remove the IR35 obligations for their client. It's important to remember, however, that engaging a contractor in this way does not automatically make an arrangement IR35 compliant, nor provide the contractor with an automatic outside IR35 status, as it is often advertised, even if the contractor is engaged for specific services and not time and materials. So to fully appreciate why this is the case, we must go back to when IR35 applies. To put it simply, you must consider IR35 when the worker is the owner-director of a company which sells the services of an individual or group of individuals, i.e. a personal service company. So if you look at the slide, you can see that IR35 applies if a worker or their family control more than 5% of ordinary share capital of the personal service company, or a worker or their family are entitled to receive more than 5% of any dividends from the personal service company, or a worker receives or could receive payments or benefits from the company which are not salary but could reasonably be taken to represent payment for services they provide to clients. Regardless of the contractual agreements you put in place, the personal service company is still a personal service company. It would be difficult to argue that engaging a contractor, regardless of whether via a statement of work or contract for services, would alleviate any requirement to determine IR35 status, nor automatically determine the contractor as outside of IR35. You are still engaging a contractor and therefore will still need to apply the off-payroll rules. Ultimately, the off-payroll rules will always apply if you're engaged in the service of a limited company contractor who is based in the UK and your business is based in the UK. So someone within the chain, whether that's the supplier or the engager, will need to consider the off-payroll rules. So when and why to engage contractors on a statement of work? The decision to engage a contractor via a statement of work should be a commercial one based on the requirements of the services being procured. You can evaluate and reposition how you procure your contract services, but IR35 status should have no bearing, as it doesn't remove the need to determine their status and issue a status determination statement, and it doesn't automatically apply an outside IR35 status. As we've touched on earlier, IR35 needs to be considered whenever you're engaged in the service of a limited company contractor. And a statement of work, just by being a statement of work, doesn't necessarily guarantee that that contractor will be working outside of IR35. It is absolutely the case that a genuine statement of work arrangement will likely be more IR35 friendly due to the nature of it. The contractor will be providing specific project-based services. There is less likely to be a fixed fee. The contractor is unlikely to become part and parcel of the organisation. The contractor is less likely to be subject to any level of control and so on. But it must be a genuine engagement for specific outcomes and deliverables. In our work helping organisations through the IR35 reform, we have seen statement of work arrangements operated where it is merely a statement of work document that requires the time of the contractor. This is simply an attempt to avoid the rules which are seen as contrived. We'll be covering how this can impact your liabilities at 2 p.m. during the Contracted Out Services webinar. As with anything to do with IR35, HMRC will always want to test whether the provisions in place, whether the agreement in place is genuine in respect of whether it's a genuine statement of work in an outsourced service or whether someone is generally operating outside of IR35. So when it comes to IR35, whether somebody is operating a genuine outsourced service or not, someone within that chain will have to consider the IR35 status of the limited company contractor. And as with employment status, the key tests are always go back to the case of Ready Mix Concrete versus the Minister of Pensions from 1968, where Judge McKenna, who was reviewing that case, set out the main key status tests that had to be considered in respect of IR35. And those three key status tests were personal service, which everybody knows as right of substitution, control and mutuality of obligations. And essentially what Judge McKenna said in that case was that if all three of those key status tests are present, you are an employee. So conversely, if only one of those key status tests is missing, therefore you have to be self-employed. In the case of ready-mix concrete versus the Minister of Pensions, Judge McKenna also said that other factors need to be considered when looking as to whether someone should be considered self-employed or an employee. And he said that anyone who is genuinely self-employed would have a financial risk. If you're in business or if you're an accountant, you run the risk of someone not paying your invoice, someone suing you. You should never be considered part and parcel of the organisation you're working for, because most contracts are only for a limited period of time. Most businesses should have business trappings. Back in 1968, they would have been different to what we would expect a business to have now. Now you'd be looking at websites, email addresses, etc., etc. And most self-employed people aren't exclusive to one engager, to one client. They have a number of different clients that they could work for at the same time. So regardless how you're engaging contractors, it's the nature of the engagement, the arrangement that matters. It's important to remember that contractors can still operate outside IR35, even when engaged for time and materials. The status tests simply need to be considered and a determination made. So even if a contractor is supplying their labour, supplying their time, supplying materials, they can still be deemed to be operating outside of IR35, provided that they can show that one of the key status tests is not present. So if they can send a substitute, they have to be self-employed. If there's no right of control over how they deliver the services, they have to be self-employed. If mutuality of obligations doesn't exist, they have to be self-employed. Other factors you need to consider when you're engaging in the services of a limited contractor is that you have to look at it as a business-to-business relationship. You're not engaging Bob, you're engaging his limited company, or, ultimately it's a business-to-business relationship. So you need to treat contractors like contractors. So you shouldn't tell them how to deliver the services, because if you engage in the services of a contractor, my expectation would be that you're engaged in the services of someone with a specific skill set, knowledge and abilities that you or your business doesn't possess. So therefore you're bringing them in because you don't have that skill set. So in theory, then, if you don't have that skill set within your business, how could you tell them how to deliver the services? If a contractor's working for your business and you require them to have a company email, then ideally what it should do is it should show that they're an external worker, whether it says EXT after their name or contractor or however you want to do it. But ultimately, they should be seen to be different to the email addresses you have for your employees. Ideally, contractors should only attend meetings relating to the project that they're working on. They shouldn't attend things like normal employee type team meetings. Wherever possible, contractors should be clearly identified as contractors. If that's some sort of building pass, name badge, it should clearly show that they're contractors again, that they're not employees. Ideally, when you're engaged in the services of a contractor, wherever possible, you shouldn't dictate where and when they work. You should allow them to deliver the services as they see fit, providing that they deliver the services that you want on time, on cost, and to the standard that you want. You shouldn't be overly bothered about where they deliver those services from. Any business funded staff social events, ideally contractors shouldn't be invited to, because they're not part and parcel of your organisation. However, if you like the contractor so much you really want them at your Christmas party, then ideally they should make a financial contribution towards the cost. If you have any employee flow charts or charts setting out who works within the business or who is doing work in the business, and whatever reason you want contractors on there, they should be clearly identifiable as contractors, external workers, etc. And you shouldn't have any contractors with any line management duties, any responsibility for someone's career progression or promotion or anything like that. You shouldn't have anyone carrying out reporting on employees. You wouldn't want contractors involved in any of the interview process for new workers. So ideally, contractors should be seen as an external business. It's the same way as if you brought Qdos in to do some work for you, you wouldn't be, you know, asking us to sit in on your interviews for new staff, etc. So evaluating how you procure contractor services. It might be that a statement of work is suitable for your business needs, but it could also be that a few simple tweaks to working practices is enough for your contractors to be determined as outside of IR35. Otherwise, it may be that the services you require simply best engage with an alternative working arrangement, such as a fixed term contract. It's important to remember that IR35 can be managed effectively, but a statement of work doesn't automatically avoid IR35. Having services procured and delivered to meet a genuine business need and a robust, considered approach to compliance is what you need to follow best practice. Ultimately, even if you are not supplying a genuine outsourced service to a client, the contractors that you're using can still be deemed and seen as being outside of IR35, provided that they can, as I said earlier, one of the key status tests, or at least one of the key status tests, doesn't apply to them. And that will be decided by HMRC on their day-to-day working practices. If HMRC carry out an investigation into a worker status, whilst they will consider the terms and conditions in the contract, ultimately it's the day-to-day working practices which are seen as the most important and the key determinant in deciding whether someone is or is not operating within outside IR35. So thank you for listening. If you have any questions, please feel free to ask via the Q&A panel. I can see a few have already come through. A recording of this presentation will be sent out at the end of the week, and if you want to learn more on this topic, we'll be covering off contracted out services, consultancies and statements of work this afternoon. So now I will just touch on the questions. So the first question is, before 2021, going direct to the client, can a contractor just take a statement of work to the client, or does it need an overarching contract too? Essentially, if you're being engaged directly by a client, then whatever happens, whether it was via a statement or not, the client doesn't make the status decision. The status decision is prior to the 6th of April 2021 is still the individual limited company contractor's job to do. So you as a limited company contractor would make your own status decision. Basically, the end client doesn't get involved in it. So the rules that we operate under now mean that contractors determine their own employment status. How do upper and lower contracts work with agencies when a statement of work is proposed over a contract with a schedule? Essentially, if it's a genuine outsourced service, then most agencies, usually what would happen would be that the supplier wouldn't go via an agency to the client. The supplier would send the, supply the services directly. If it was the agency supplying the workers, again, the outsourced service agreement would still work in the same way. If they were supplying if the agency was supplying a genuine outsourced service to the client, then obviously via a statement of work and a managed service agreement, then it would be down to the agency to decide on the status. But the rules around what is and isn't a genuine outsourced service would apply to whoever is supplying the services to the client. We've prepared a contractor service agreement that includes an addendum, a Schedule 1 services. Should this read statement of work as this specific word is important? I mean, ultimately, whatever you want to call it is entirely up to you. If it's a genuine, if you're doing a managed service agreement with a statement of work, but you want to call it a schedule of work or a scope of work, that's fine, providing it is, again, providing if you're ever unfortunate enough to have a HMRC investigation and they looked at it, they could see that it was a genuine outsourced service. What you call it is entirely up to yourself. That doesn't matter. What if your company falls under the annual turnover that new IR35 legislation applies? Essentially, if the client that's engaging the services is classed as a small client, small business, I should say, then it's the individual contractors who determine their own status still. That doesn't change. So it only, the new rules, if you like, only affect medium or large businesses. Can you define mutuality of obligation? I'm an employee of Qdos. As an employee of Qdos, there's an expectation on my part that, you know, within reason in this current climate, that this time next week, next month, next year, I will have a job, that I will turn up for work. If I come in and do the work that's presented to me to the best of my ability, to a standard that's required, then I will be paid. So there's an obligation on my part to turn up for work, and there's an obligation on my employer's part to provide me with work and pay me for my services. And there's an expectation on both our parts that this time next week, next month, next year, I will turn up for work. And there's an expectation on their part that if I do turn up, they will pay me. So neither one of us believes that my contract, if you like, will end in 3 months' time or 6 months or whatever. So whereas self-employed contractors, self-employed people, I should say, they don't have that expectation. I'll give you a very basic example. If you're a gas safe engineer who's self-employed and you go into a house to fit a brand new boiler, once you fitted that boiler, that's it. The job is over. So there's no expectation on your part that the person you're doing the work for will offer you further work, and there's no expectation on their part that if they offer you work that you will accept it, because you might have other jobs to go to. Whereas as an employee, there's an expectation that if work is offered, it will be accepted. And that essentially is mutuality of obligation. Could a contractor be involved in interviews when looking to bring in another contractor and not an employee? We actually have been asked this question a lot. And the answer is a contractor can be involved in interviews if you're looking for someone to comment on someone's technical ability, or, you know, has this person got the genuine skills to do the work we want? However, they shouldn't have the ultimate sign-off. The sign-off should always be someone within the business. You would never lose an IR35 argument with HMRC because that has happened. But again, it would detract from your argument as to why someone was self-employed, because HMRC would say by involving them in the interview process, that then makes them, in HMRC's view, part and parcel of your organisation. Would a fixed term contract indicate in or out of IR35, or would this be similar to statement work? The length of the contract doesn't make any difference to whether someone should be in or outside of IR35. If the contract is for a limited period of time, but it's a self-employed contract, because I assume you're not talking about a pay-as-you-earn one, then again, everything always comes back to the key status test. The three status tests is how you decide whether someone would be seen to be self-employed or not. What if you provide a contractor with equipment, i.e. laptop, or will we be able to get them to rent the equipment from the company? Yeah, basically a lot of businesses that we deal with will flatly refuse to let any contractor use their own equipment. I'm talking about laptops and computer equipment mainly, because they don't want to run the risk that the contractor could plug in there, and I'm not technically minded, so excuse my phrase, they plug in their laptop to their mainframe and run the risk of it, virus or doing something disastrous to their computer system. So most clients will say, no, you can't use your own equipment. And HMRC don't really have a major problem with that when it comes to computer equipment, for the reasons I've just set out. But if you want to say to your contractors, you have to use this equipment, and we'll rent it to you, then ultimately you're engaged in the contract. You can do what you like. In a statement of work arrangement where a limited company contractor is being used, does the agency or the client have to do the SDS? If you're providing a genuine, If you're looking at an outsourced service, then it's the business that's supplying the outsourced service that would do, and it's a genuine outsourced service, would do the SDS. If it's just a statement of work where the contractor has got a statement of work showing what work is needed to do, so it's still labour and materials, and it would always be the end client that carried out that issued the status determination statement. How does the statement of work model affect the liabilities of a recruitment agency that is facilitating the relationship? This sounds like the agency might be moving into an outsourced consulting territory. Yeah, exact territory. Yeah, basically, if an agency is providing workers under a statement of work that is outsourced, then yes, it would be the agency that would be supplying the service, not the contractors. So all that happens is whoever's actually supplying the outsourced service, if it is a genuine outsourced service and they're classed as a medium to large business, then they would be the people that issue the status determination statement to the contractors. For line management duties, what if the contractor only does the provisional assessments and provides these to their client engager? Or does this mean that all program project managers and interims cannot be contractors? Without doing a whole separate presentation, essentially what we talk about, when one of the early slides where I talked about the key status tests, etc., that HMRC looked to based on Judge McKenna's judgment in the ready mixed concrete case. The most important things you need to consider when considering IR35 are the three key status tests: personal service, right of substitution, control and mutuality. They're the most important thing. However, in the slide I showed other tests, lesser tests we call them, financial risk, part parcel, business tracking, exclusivity. And essentially those lesser tests are what you use to support your reasons as to why a contractor is outside of IR35. So if you're arguing the right substitution, control and mutuality, blah, 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 but you want to bolster your argument with other points as to why this person is generally self-employed, you talk about their financial risk or them not being considered part and parcel of the organisation. Conversely, if you have a HMRC inquiry, HMRC will use any of those lesser tests to support their arguments if they think they work in their favour. So if you say to HMRC, yes, we have contractors as part and part on the reporting side for employees of the business, HMRC would say, well, then that way you're considered them part and parcel of the organisation, and they would use that to undermine your arguments as why a contractor is generally self-employed. But you would never lose the argument on that point alone. Can time and materials payments against monthly milestones still be applied to statements of work and still be outside of IR35? With a statement of work, essentially, if it's a genuine outsourced service, if it's a genuine service that's being provided, then it can be outside of IR35. But you have to look at the provision of the service as a whole. It has to be that the client who's receiving the service has no input into who the workers are, has no say about how many workers are sent. Essentially, all the client receiving the service should be interested in is this service at a cost I'm happy with, and are they delivering it on time, on budget, to the standard I want? Anything other than that. But you have to look at the whole service provision to make the determination as to whether someone would or not be considered, whether it would be considered a genuine outsourced service. Email addresses, if we're unable to distinguish someone as a contractor via the email address, how significant is this? Would a contractor's signature on emails be sufficient? Yeah, as I touched on, the bit about considering, it's a business-business relationship and email addresses and treating contractors like contractors, it comes back to the point I made a moment ago about the lesser tests. You would never lose an argument with HMRC over someone's status just because you can't identify them from their email address. But by doing these things, by showing that you're treating contractors differently to employees, helps bolster your arguments as to why someone should be considered generally self-employed. So whilst they'll never lose you the argument, they can help you win it. So if for whatever reason your system isn't set up where you can identify contractors as, by putting external on their email or whatever it may be, like it isn't the end of the world. It's not the worst thing that can happen. Post April 2021, if an agency is a small, medium enterprise, then who is responsible for doing the statement of termination? If the client that the contractor is working to is a medium or large business, it's the client. I've just got time for a couple of more questions. Where large international companies with overseas legal teams are enforcing statement of works on small recruitment agencies in the UK, when we know that it's not a genuinely outsourced service, how can we fight against this? It feels like taking on a Goliath at times. Essentially, if the company is wholly overseas, then IR35 doesn't apply. And we touched on this in one of the webinars we did yesterday. So I don't know whether you could register to get that sent out to you, but essentially if the engager, if the client is wholly overseas, then the IR35 rules don't apply. Fixed price contracts are often difficult to craft when there are other parties in the chain. Who may miss their deadlines? Are there examples of day rate statement of works that are compliant? Ultimately, you can't just look at one aspect of you have to look at the service as a whole. So even if there are day rates in there, whilst not ideal, providing everything else ticks the right boxes in respect of someone's status, you can still have an outsourced service provision that is genuine, but you have to, you have to look at it as a whole. You can't just look at little parts of it. You wouldn't, is the service being provided as a whole, and what that entails and who's involved and how it's all dealt with is where the ultimate decision will be made. And the final question I've got here, would a status determination be legitimate if it was only been signed off by the agency, not the end client? No. Essentially, how the off-payroll 2021 rules will work are that if a contractor is engaged via an agency with an end client, and the end client is a medium to large business, it is the end client who has to make the status determination statement. If the end client doesn't issue a status determination statement, the liability sits with them until they do. Thank you everybody for taking the time out to listen and to ask the questions. As I said, we've got one more webinar this afternoon, and that's about contracted out services. So if you've got a chance to join that, it'd be appreciated. And thank you very much for your time, and thank you for listening.